100 lot home subdivision, it applies to all of those instances. So that's a whole regulatory scheme. And then finally, we have an optional scheme that we can use for co-ops, which you'll understand when I go through this, which would be your corporate securities laws. And that would apply to how you want to sell your co-op memberships. So let's start with limited equity co-ops. Limited equity cooperative law is now, it is no longer in the Health and Safety Code, it is now in the Civil Code at Section 817. The statute pretty much is similar, and I'll tell you the few distinctions that have been made since the latest update. But the idea behind a limited equity co-op is that it's a restricted cooperative. The equity stays within the co-op, and so it's regulated by the statute. And if you don't comply with all the requirements of this statute, you are not a limited equity co-op in California. You're just a regular stock cooperative. So here's some of the attributes of a limited equity co-op in California. The distribution of the assets have to be restricted to distribution to a charitable purpose if you ever dissolve a limited equity co-op. So they cannot go to the members, they cannot go to any private individual who could make a profit. So if a limited equity co-op were to dissolve, you would have to distribute the assets to some other 501c3 nonprofit. The new statute also puts a lot of restrictions on dissolutions of limited equity co-ops, and then contains a process for a hearing if you want to dissolve and what you have to do. I have to say very few limited equity co-ops I know of have ever dissolved. I had one that wanted to and couldn't quite make it work, and so ended up not. So it's not really a big issue. The corporate equity, meaning that the value of the building that is not in the memberships, has to be used to improve the property or for charitable purposes. So once again, nobody in particular is making money off of the co-op. The big issue with limited equity co-ops, probably the most restrictive part of the statute, is that the transfer value of the memberships has to be restricted. So your transfer value in a limited equity co-op can only increase from the original transfer value for the first person who bought that membership by some sort of index. You have to set it to an index, and it can't be more than 10% annually. And then you can also increase transfer value by capital improvements that the member may have made. But you have to limit the amount of equity that a member can receive to be a limited equity co-op. And this is probably where we run into the biggest problem. We have a lot of HUD co-ops in California that were formed in the 60s before this definition came into law. They have restricted equity, but they do not restrict the transfer value by this 10% maximum. And therefore, when the limited equity law came into effect, they did not qualify, and they are not limited equity co-ops. So everybody thinks they are, but they're not really, they don't meet our statutory definition. And then, as I said, if you don't meet these criteria, then you're a stock cooperative. You're just a regular cooperative. You're not governed by the transfer value provisions. So what do you have to do to form a co-op? The first thing you do is you really need to form your association, your members' organization that's going to own and operate that co-op. And there are a bunch of documents that you're going to need to do that, and we'll walk through those. Your articles of incorporation, you should be an incorporated nonprofit corporation. We'll talk about those bylaws. Those are your governing documents of how you're going to conduct your meetings, who gets to vote. Your declaration of restrictions, this is one of those documents that really applies to condominiums, but because people think condominiums and co-ops are the same, we get to do this as well. And this is a document that gets recorded on the property. And the point of it is so that there is notice to anybody who is buying a property interest that this property is restricted. Since, as Margaret talked about in co-ops, we don't go through the real property recordation system when you transfer memberships, very few people ever look at this declaration. And so we try to keep it as minimal as possible because we think really it's your bylaws that govern what you're doing. Your occupancy agreement is basically the member's lease. It governs their relationship with the organization that owns the property. The subscription agreement is your initial agreement to purchase the unit. So we use subscription agreements when we're forming new cooperatives. After the initial sale of the units, we tend to not use subscription agreements. We may use a purchase and sale agreement between the members who are selling. And then you need your budget for your initial operating year. This is what's going to tell you how much your members need to pay monthly. So let's talk about the Subdivision Map Act for a moment. Hopefully, if you are doing new construction, starting with a piece of dirt and you're going to build a building on it with a cooperative, you don't have to deal with the Subdivision Map Act. Because what you're going to have is a single parcel of land, you're going to build a single building on it in the way, or multiple buildings on it, but that building, those buildings are going to be owned by a single entity. So it is not a subdivision. You do not need the land actually to be in separate parcels. That means you don't need a subdivision map, which is all for the good, because a subdivision map requires that you get an engineer to draw a map and parcel lines. You have to submit it to your local government, and it has to be approved by your local government. And they most likely put conditions on it, which will not only cost you money, but take you time. Unfortunately, the Subdivision Map Act does apply if you are converting an existing property. So if you want to acquire a 100-unit building and convert it to a co-op, under the definitions in the Subdivision Map Act, you have to get a map for that property. This makes absolutely no sense because you're not subdividing the property, but because of the way the statute defines cooperatives, you have to get a map. And we've been through this. Rick and I have been working on a co-op in San Francisco, a conversion. And we probably spent I can't even think how many hours trying to explain to the engineer doing the map what this map was going to look like, because to the engineer it was a single parcel. We kept saying it's a single parcel, so why am I doing a map? Well, because the statute says you have to do a map. And so we went back and forth and getting the city convinced of this whole thing, but the statute says we have to do a map. And it probably, I don't know, Rick, I think it probably added $20,000 to $30,000 to the cost of the transaction with the engineer, and yeah, and the time. It was just ridiculous.
I'm trying to wrap that around my brain. If a co-op is a corporation, can't it own multiple assets?
Yes.
And distribute those assets out of development? So why would it need a map?
Because the statute defines a subdivision as a conversion of an existing property to 5 or more units of cooperatives.
Okay.
That's the only reason. And once again, I don't think when it's written, people understand co-ops. That there's a single owner, that you as a member of a co-op, you have a right to occupy, but what you own is a membership in the corporation. You don't actually own the physical unit you live in. Right. You rent that. I don't know.
Condominiums as well?
Oh, a condominium definitely is a subdivision. Because a condominium, what you own is the walls. I mean, you have a deed that gets recorded in the land records that says this is your unit within these 4 walls.
So they survey the building and describe it as they would a lot?
Yes, exactly. And you'll see, you know, in a high-rise building, you'll see what's called a vertical map.
It's a 3D map.
It's a, yes, we moved into the new dimensions, yes. The other problem with having to come under the Subdivision Map Act is that a lot of jurisdictions have condominium conversion ordinances that are designed to keep the stock of rental housing in place. Unfortunately, a lot of them sweep co-ops into their condominium conversion ordinances. So San Francisco, they have a lottery every year. Only so many units can convert to condominiums each year. If you want to convert, you might get swept into an ordinance like that where you have to go in the lottery. I forget where I was looking recently. In San Jose, if you want to convert a property to a condominium or a co-op, not only do you have to do the subdivision map, but because of their condominium conversion ordinance, you have to bring it up to current code, which most buildings are not up to current code. So it becomes really expensive. So if you're looking at an existing building, you really need to check in with your local government first and figure out what the restrictions are going to be on doing a subdivision map.
Is Is it possible to convert it into 5 and then 5 again, some way like that?
We have spent a lot of time looking at those questions, and actually there are provisions in the Subdivision Map Act that are designed to prevent that. And the one thing I will tell you is that under both the Subdivided Lands Act and the Subdivision Map Act, violations of the act can result in criminal penalties. So I'm not going to give anybody advice to try to skirt the act, because I'm not the one that's going to get arrested. So, but yeah, they've got you coming and going. A jurisdiction that wants to do co-ops will help you find a way to do this. If the jurisdiction doesn't have any interest, they've got every conceivable way to make it impossible. So.
When was that particular requirement passed? I mean, has it always been there from the beginning?
It has been there at least probably since the 50s or the 60s.
The subdivision.
Mm-hmm. So the Subdivision Map Act is one of the older codes in California law, and I think the co-ops have been in there maybe even earlier. It's quite an old statute. Yes.
In your experience with looking in this, especially around the area, are there some restrictions that you seem to be, I mean, I would think they all have an interest in maintaining their stock of affordable housing. So, do some seem to sort of not get it and not want to promote it?
Could you repeat
The question was, are there jurisdictions that really are not interested in co-ops or seem to not want to promote them? I don't think I've encountered a jurisdiction that really is anti-co-op. I mean, what I encounter is jurisdictions who don't understand them and are understaffed and don't really want to take the time to sort it out, and it's not a high enough priority for them. I mean, San Francisco actually really wants to promote it and has done some stuff to try to promote co-ops, but they didn't completely get all of the hoops that would come up. And so the one Rick and I have been working on was sort of the first time they experienced, like, oh, this is a problem. So, slowly you work through it, but it's a real struggle. Yeah.
I think the important thing is if in your community you want to develop co-ops, you need to work with the policymakers to make those changes. And the city of Berkeley has a categorical exemption in their condominium conversion that just says if you're a limited equity co-op, you're not covered.
Yeah.
And
so they affirmatively encourage.
You talk to your housing department, to your city council members, and so on, and try and make sure it gets into your housing element.
Right, and that's exactly the case. You really need to educate the government workers and the local politicians, because they're just not familiar with it. So I think with some education you can get changes in your local legislation, which is certainly easier than on a statewide level. And your local governments have a lot of control of the Subdivision Map Act. They can't waive the map, but they can make your life a lot easier because it's all enforced at the local level on the Subdivision Map Act. On the Subdivided Lands Act, we're going to get into a different problem.
But I understand a little bit about what the incentives would be for a developer to create condominiums. But now, how would that differentiate? Would a developer ever be interested in creating a cooperative? And
yeah, I mean, I got to tell you, I get phone calls quite a bit from developers who are interested. I can't tell you why. I mean, I often ask them what, and people think it's a type of housing that there are buyers for, and they think there's a way that they can make some money on it, and so they want to do it.
Karen, most of the senior housing co-ops in Minnesota were done by developers, and they're mid to upper income. But they just, they were popular and they sold them, and they're, they try and get the contract to the management company, just like any other. And they were good developers. They're a little more public-minded developers than a typical one.
To live there.
Yeah, and there's a fair number of market rate co-ops in San Francisco. You'd be surprised at what is a co-op in San Francisco that sell for a lot of money. The units are quite expensive, and somebody developed those, including found it to be a profitable exercise, so they did it. So
The condominiums or co-ops for the developer is the same cost probably.
potentially. The one thing I have heard from developers, and I don't want to get into this too much because that's like a whole day course, is condominiums, there are a lot of issues with construction defect litigation for developers. So a lot of developers are pulling back from the condominium market, and there is a feeling in co-ops that there's less of that, because in the co-op, if you're going to sue on construction defects, you're also suing yourself because you own part of that corporation. So that may be one basis. The construction defect issues have really put a damper on the condo market, and it's now starting to pick up as insurance has tried to deal with it. So that may be why. So, yeah.
It's possible that developers are looking at the co-ops as an option for affordable housing because of the inclusionary requirements, or the requirement that a certain percentage of the units they build be affordable housing.
Yep, that's exactly the comment was it's also a way to meet your inclusionary and affordable housing. There's also, you know, the co-housing movement. There are a lot of people that are looking at ways to live in housing that's more community oriented, and most of the co-housing projects I've worked on are condominiums, but there is some of the co-housing groups spend a lot of time discussing co-ops, and have thought of going the co-op route. So
Any of them accomplished it?
co-housing groups, none of the ones I've worked on, but I do think there are a couple. So, okay, so once you get through the land process of dealing with your subdivision, you have to, when you sell the memberships in your co-op, you are basically selling what the state of California considers to be a security. You're selling an investment, and that is a regulated transaction. So there are two ways in which you can sell your memberships. You can sell your memberships under the Subdivided Lands Act, or you can sell your memberships with a Corporations Code securities permit. So we're going to walk through what that entails. The Subdivided Lands Act is regulated by the Department of Real Estate in California. It originally was generated, it used to be that when you wanted to sell subdivisions of any sort, you went through the Department of Corporations, you did an offering like you would do an offering for a large public corporation, and you sold. Sometime in the late 60s, early 70s, the Subdivided Lands Act came in because there was a feeling that real estate was a little different than buying an interest in a corporation. And so what we got was the statute, which is definitely more geared towards real estate. It really is geared towards a different type of development from what co-ops are. And this is sort of my mantra. Once again, I don't believe the Department of Real Estate really understands co-ops, and you'll see why when we walk through the challenges we have with them. So they've set up regulations that don't work very well for co-ops. What the Subdivided Lands Act says is before you sell an interest in real property in a subdivision, you have to obtain a public report. And so effectively what you have to do is send a lot of materials to the Department of Real Estate. They review them very carefully. They send them back to you with comments 2 or 3 times. And then eventually they give you a public report, and it is to me the most incomprehensible document ever, but it is designed to be a consumer disclosure document that you are required to give anybody who's interested in purchasing, along with all of your governing documents, and basically trying to tell them what it is they're buying and what they're getting into. And the whole intent of this is to protect those buyers from making a bad investment and make sure that they have full disclosure. In my view, if you wanted to give them full disclosure, you would at least put the report in a format that people could read. But they didn't ask me. So they're going to go through all your documents. Sometimes the process can be really simple or quick. It can be okay. But a lot of times they're going to send it back, and they're going to say, no, we don't like this, or we don't like that, or you know, you didn't put these provisions in your documents. And so it can take, you know, 6 months to get through this process with the Department of Real Estate. They're also going to make you prepare your first year's budget and submit it to them in their format. because they want to make sure that you've taken into account all the costs so that people are fully aware of what they're going to pay. The Department of Real Estate has special regulations applying to cooperatives, and this is where we struggle with them. Their regulations say that they will not issue a public report that has a blanket encumbrance unless you meet certain conditions. And by blanket encumbrance, I mean a single loan that covers the entire property. And that is typically how co-ops are developed. Is you go out and get a bank loan, it's a single loan to the corporation that owns the property, and you as members, when you pay your monthly charges, are paying a part of that loan. The problem that the Department of Real Estate has is if that loan is foreclosed on, if for some reason the corporation doesn't make their payment, all the members who live there could potentially be displaced by the foreclosures. So in an effort to avoid that, they generally will not issue a public report if there's a blanket encumbrance, unless you get these assurances. So the assurances are you have to get the lender to say, if I foreclose, I won't displace anyone. Maybe, maybe not. Will they do it? And you have to give them some assurances that the loan will be paid, which usually takes the form of you have to have at least 6 months of your debt service payment in reserves at all times. That is a high standard for reserves, particularly when you're starting up. So that's a little bit of a challenge. There is an exemption from the Subdivided Lands Act for limited equity co-ops, but you have to meet all of the conditions of the exemption. And if you meet all the conditions of the exemption, you do not have to get a public report to sell your memberships. You can go through the exemption and then just go sell your memberships. It's a fairly easy exemption to get. You just send a form to the Department of Real Estate, but when we walk through the conditions, you'll see you do have to make sure your co-op conforms to all of these standards. So the first requirement for the exemption is that you have to have at least 50% of your total construction costs, or $100,000, whichever is less. So typically $100,000 from any one of these lending entities. This was also amended this year, so what was added is we can now get money from PERS, STRS, and the Federal Home Loan Bank System, which actually is a really good thing because any of their constituent members, if they give you money, will count you towards this exemption.
Do you mean lend you money or give you money?
Lend you money.
Okay.
It can be a loan. And you can combine the money from these identified sources with a local source to get to that $100,000 threshold. So we have been known to take a lot of money from a local government and $5,000 to $10,000 from the National Co-op Bank, and that meets this requirement because you just have to have it in a combination of one of these sources. But you can't just have local government money to meet this requirement. No more than 10% of your development cost can be provided by the members. So when you go to sell your memberships, the total amount that you can collect from them, whatever they pay for their initial share purchase, can't be more than 10%. You have to have a regulatory agreement on the cooperative that regulates it as a cooperative, and that regulatory agreement has to be approved by the California Department of Housing and Community Development. Primarily, you just have to find some attorney at HCD that's willing to look at it and send you a letter. HCD does not regulate co-ops. They don't really do co-ops. And the last time I called them about this, I left a message for an attorney saying, I need to talk to you about a co-op, and he didn't return my call and didn't return it. And finally, I got him. He goes, I didn't want to return your call because we don't have any money for co-ops, so stop bugging me. I was like, no, I don't want your money. I just want your signature. He was like, oh, great, fine, whatever you need. So, you also, the government body that executes that regulatory agreement has to be satisfied that the governing documents provide protections to the rights of the members. This has never been a problem for us in getting the exemption until recently with the co-op in San Francisco. Because the city of San Francisco took the position that it's our regulatory agreement. One of the requirements is we have to be satisfied that the members are protected. Effectively, we, the city of San Francisco, are being asked to step into the shoes of the Department of Real Estate. We need to make sure that you've done all these things. They went out and hired a separate lawyer. It took them 4 months to find an attorney that would do it because Kim said, I might be the leading expert in co-ops. I may be the only person in California that really pays attention to co-ops. They couldn't find anyone. So they found a condo lawyer who looked at the documents and went nuts because they didn't conform to a condo document. So it's been a really challenging process there to get the city and the city attorney's office to sign off, because they keep getting advice about condominiums and we keep having to say, no, 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 this is a co-op, this is different. So be forewarned, some governments will just sign it. They don't care, they don't really pay attention to this. You might get a city attorney's office that actually reads the statute and starts to get concerned. The government body executing the regulatory agreement has to get a legal opinion that the co-op meets the requirements of the exemption. So that's where my firm comes in, or other lawyers. We have to give a legal opinion to that local government saying, yes, this is all okay. And that is going to cost you some money, because when attorneys give a legal opinion, we are putting basically our malpractice insurance on the line for you. So people always get upset, like, how can you charge me so much for a letter? But what I'm doing is basically putting all of the faith and credit of my firm behind your co-op by guaranteeing this to the local government. So you're going to have a lawyer, because the law says. And then after that, you just file this form. So the whole thing, you go through all this, and literally the form has like 5 blanks. You fill it out, you sign it, you send it in, and you're done. So it always seems very like, the end of the process is so minimal compared to getting there. The other option, if you don't want to go through the Department of Real Estate, if you're a stock cooperative and you're going to have a blanket encumbrance, so you're not going to get through the Department of Real Estate easily, your other option is to go through the Department of Corporations and do a Corporations Code securities qualification. This is basically saying I'm selling securities just like Yahoo sells shares in their corporation. It's a limited offering, so the requirements are certainly less significant than what they would be for a large corporation offering. But you do have to prepare a disclosure document, and there are very specific requirements for that disclosure document. We have done this a couple times. We did it with a mobile home park most recently. It went really well. We did spend a lot of time on the disclosure document, making sure that we had put in all the information that the Department of Corporations might want about how the co-op would function and about its budgets. Once we submitted it, we got the approval within about 15 days. So the Department of Corporations is known for acting faster than the Department of Real Estate, but the trade-off is that you really do have to do a lot of upfront work to get there. So after you've jumped through all those hoops, what do you need to do to actually have an entity that runs your co-ops? As I mentioned before, you need your articles of incorporation. This is basically your charter as a corporation owning the property. There's very specific requirements in the Corporations Code as to what you have to include in there. If you're a limited equity co-op, you must be a public benefit corporation, which is a particular type of nonprofit, which is fine. It really doesn't, there's nothing bad about that. The only other thing I will mention is that under the new statute for limited equity co-ops, one of the things that has to be in your articles is that you cannot amend your articles or bylaws without a 2/3 vote of your membership, which I think is going to be a little challenging for people. Bylaws, this is how you govern yourself. Your bylaws are going to be the document that your board of directors is going to look to for how do we conduct meetings, how do we handle this problem that came up, how is voting regulated, who can vote, how many votes do we need for certain items, how do we do our budgets. It's all going to be in there. This is where the Davis-Sterling Act comes in, because this is where most of the regulations from the Davis-Sterling Act we would put into your bylaws. And in part we do that because we want your board members to understand what they have to do. Whether it's in the bylaws or not, you are subject to the Davis-Sterling Act, But if it's not in the bylaws, it's very easy when you're a board member who does this as your second career to forget everything that's in Davis Sterling, and there's a lot in there. Some of the bylaw provisions that we would include, who's eligible for membership? Do you have restrictions on that? Sorry.
Where can you get that codes, that information?
The Davis Sterling Act?
Yeah. And codes, corporation codes.
The easiest way is probably the internet. That's
Okay,
where
on the internet.
a law library or your local library should have them.
Okay.
So I'm trying to think where else. I think the library would be the best place if you don't have the internet. So membership eligibility, who can live in the co-op if you have restrictions on income, if it's a senior co-op, any of those things. Transfer of membership, how the transfers actually occur when somebody wants to sell their membership. The bylaws are also where we would put in the transfer value restrictions. Voting provisions, who can vote? Can everybody vote on everything? If you haven't paid your membership fees for months and months, can you vote? Can you be on the board if you haven't paid your membership fees? Those are the kind of things you want to consider in your bylaws. Board members, how many? How are they selected? Do you have outside board members? Some of our co-ops have outside board members, people who are not members. Most of them don't, because people who aren't members don't really want to come to your meetings most of the time. I'm just going to be honest with you, because it doesn't really affect them. But some of them do, and it sometimes works okay. But also the numbers. I really caution people to think about the numbers of board members. Too large and it becomes unwieldy, too small, and it becomes a problem of becoming a very insular little group. And turnover of board members, and can people just, be lifetime board members and run over and over again?
What
Yes.
would be the sweet spot for board members?
Well, it somewhat depends on the size of your co-op. When HUD used to be in the co-op business, they had these model bylaws that I loved. They had the check the box board members. If you have X number of members in your co-op, you should have 7 board members. If you have 250 members, you should have 9. So it depends. 3 is pretty small no matter the size of your co-op. And frankly, anything above 9 starts to get problematic of getting everybody together. So you're somewhere in between there. Most of our boards are 5 to 7 to 9. Reporting requirements. Davis Sterling requires a significant amount of annual reporting to your members so that they know what you're doing, and we put that in the bylaws so everybody knows what they're entitled to. And assessment procedures, how you are going to allocate assessments among the members, the monthly charges, and also how you are going to increase those on a regular basis. And Davis Sterling does limit the amount that you can increase your monthly assessments on an annual basis without a vote of your members. The declaration I've talked about, it's like my least favorite document and nobody reads it. So I try to minimize it. The one thing that we do put in here, lien procedures. The cooperative corporation, if you don't pay your membership fees, the cooperative corporation can lien your membership and foreclose it. And so we do put that in the declaration because that needs to be somewhere. We hardly ever use that as a remedy. It's a challenging remedy to use in the first place, and it's not very effective. Other documents, your occupancy agreement, which is your lease. Obviously, we want to make it clear in the occupancy agreement that one of the obligations of the member is to pay the monthly charge. Yeah.
What do you use in lieu of lien procedures?
We use eviction. You are, as a member of co-op, you are a tenant. So you do come under landlord-tenant laws. It is not the easiest eviction to do. The judges need education just like everybody else, but that's the primary remedy that co-ops use. And generally, I've been working with co-ops for 23 years. I've only had 2 evictions go from start to finish. Usually people work it out.
And so your eviction issues would be under transfers and within the bylaws, right?
Transfers,
I mean, if you
oh,
evict somebody, you basically are transferring, they might.
yeah, what we do in an eviction with the transfer is once the eviction goes through, the co-op can sell that membership and the member gets the proceeds of the sales minus the costs.
And that would be in the
incurred.
bylaws?
Yep,
Okay.
yep. So that on this slide, that's also, we put that in the occupancy agreement, the termination provisions of how we evict and what happens. Yeah, in the back? You can give it to me now.
Okay, so I guess it's twofold. So that regulation supersedes the bylaws, correct? So if your bylaw, we've been working with HOAs, well, we can't help it, and their bylaws seem to go out of date often because the things are
Yep.
changed a lot. So what we were told, not by a lawyer, was that it doesn't matter, your bylaws actually don't matter, you just follow theirs.
Which is true to the extent Davis Sterling regulates. So Davis Sterling doesn't regulate everything that's in your bylaws.
Then
And
that's my next question is, does Davis Sterling have, does it regulate the co-op housing the same way? Is it exactly the same for HOAs? Or why am I
Yes.
asking how it relates to HOAs?
yes,
I'm understanding how it relates.
yes. The Davis Sterling treats condominiums, subdivisions, planned unit developments, and cooperatives, both limited equity and stock co-ops, exactly the same. Ergo, Davis Sterling is not helpful. I mean, it's just, and also it's really designed for when you start getting into it for 500 unit developments. And you know, when you have a 20 unit co-op that has to come up within this regulatory scheme, it's burdensome. Yeah.
Would you suggest that the regulations be changed to create a tier?
I have been suggesting that for 20 years. I would love to do that. The problem is that A, there's no constituency in Sacramento for co-ops, as best we can tell, and B, they're kind of busy in Sacramento. So we need to find a constituency, and Rick and I have been trying to find some like law student to actually write legislation because we don't have time. But yes, I think we need something because it's just becoming unduly burdensome on co-ops to comply with all this stuff. I mean, just one of the things Rick does is these elections. To do your board elections now is ridiculous. You have to have an inspector of the elections, you have to do it by written ballot, you have to follow all these procedures. And when you're, 20 units, it makes no sense.
For all co-ops?
All co-ops, there's no size distinction, it's just there. So that's the struggles that we're having. Yeah.
Who typically does the Davis Sterling yearly reporting? Is it the property manager or the board, or you
If you've got a property manager, your property manager should be doing it. If you are self-managed, then your board has to do it. So, yep.
Are any grandfather clauses in the new code?
No.
So existing co-ops need to come up to speed?
Yes. This is a self-regulating statute. So, your risk of not doing what Davis Sterling says is you're going to get a member that eventually sues you. And we haven't really seen that. I have co-ops that are all over the spectrum of compliance. There are some that are really, really on top of it and do all the reporting and all, their members get, a stack that thick every year of all the reports. And there are some that really take it as, I'm going to give my members what they need. I'm not going to inundate them with a ton of paper. And there's some that ignore it. And, until a member, you get into a membership fight, I don't think you have a lot of risk if you're an existing co-op. So. Yeah.
I see this word assessment a lot.
Mm-hmm.
And on your little sheet right here, it says real estate value or tax levied on a person or property by a governmental unit.
Mm-hmm.
Why is it we always have to get an assessment to do improvements?
Well,
When it
you
says-
mean in a co-op?
It says value though.
Right, well, the assessment process is this. If you are a cooperative corporation and you need to put a new roof on your property, you have a limited number of ways to pay for that. You can go get a loan from a bank, which has to be paid monthly, which means the members have to pay that monthly. Or you can go to all your members and say it's going to cost $10,000 to put a new roof. You know, there's X numbers of you each have to pay X, and that's what's called an assessment. It's just called an assessment. Basically, it's like you all are the people that own this property and you have to pay to maintain it.
What we're getting at is, though, is that the assessment that they're trying to put on us is we're in the process of doing a rehabilitation. And so there's a rehabilitation assessment to be done. And we went through a rehabilitation assessment 2 years ago, which cost like $200,000 for 274 units. And now they're trying to put another reassessment on us, or another assessment on us for doing DVI violations in San Francisco, by the way.
I think I know which co-op.
So we're trying to get around doing, you know, spending gobs of money on something we've already done.
Well, so this is where Davis Sterling can be helpful, because Davis Sterling regulates assessments. And what it regulates is, first of all, there's all the budgeting requirements of Davis Sterling is that you as members have to get an annual budget. You also have to get reports on reserves. You also, if there is an assessment, a special assessment like that, that exceeds 5% of the co-op's budgeted annual budget, it has to be approved by the members. So, and if the assessments increase by more than 20% in each year, they have to be approved by the members. So there's all that. Now, I'm going to tell you, I know what co-op you're in, and the attorney who represents you believes you're not covered by Davis Sterling.
Yes, I want to get that.
So, I disagree with that interpretation, but that's...
Thank you. Yeah, I really hate that word assessment.
I understand.
Maybe a little bit of a misunderstanding, because in the glossary they refer to a real estate assessment, which is something different than the term assessment, which also can be called charges of rent. So there are two different concepts.
So I'm just going to wrap it up. Kim's given me the flag. But some of the things that Davis Sterling covers is obviously your annual reporting. We've talked about voting. I've talked a little bit about certain rules in the co-op. If you, as the board, want to change certain types of rules, which Davis Sterling calls operating rules, there's basically a significant noticing procedure to your members, and then your members essentially have the right of referendum to overturn those rules. Enforcement of assessments, we've talked about liens. Davis Sterling also has a pretty significant alternative dispute resolution process, with the goal being that disputes between members and the corporation, first you try to resolve them with alternative dispute resolution before you go to court. I always think that's a good idea. Most disputes, as I say, do tend to get resolved that way, so that works pretty well. And that's it. So I know that was a lot of information.